All right, I'm going to go ahead and start with the introduction. As I mentioned before, my name's Laura Good, and I'm one of the co-founders of StartupSac. And Jeff, it would be okay to spotlight me now if you haven't already. And then Jeff Bennett is the other co-founder of StartupSac. And we're bringing you these office hours once a month. And today's topic is intellectual property control and protection. So before we get into that, I just wanted to let you know a little bit more about StartupSac in case this is your first time attending a StartupSac event. StartupSac is a nonprofit that's focused on accelerating Sacramento's startup and innovation ecosystem. And our program today is one of the many programs that we have available. StartupSac office hours is education for founders, and every month we feature a new topic. We also have some other events that we'll be telling you about later on. But we'd really love for you to take a look at our website, startupsac.com, to see all the resources that we have available. We'd also like to thank our sponsors who make this possible. Our annual sponsors are Witten Law, SMUD, Bender Insurance, Nivagen, Stoll Reeve, Weintraub Tobin, Ernst & Young, Clifton Larson Allen, and Moneta Ventures. So without their generous support, StartupSac would not be possible. So thank you very much. And our special sponsor today is Weintraub Tobin, who not only supports us through sponsorship, but also is sorry, Mary, I'm just trying to figure out, I can't read and show my slides at the same time. Hold on.
Do you want me to read that? I can read that for you.
Yes.
Too.
Yes, please, Jeff.
So our presenters today are from the law firm of Weintraub Tobin. And Weintraub works with and supports the startup community statewide, including sponsorship of StartupSac. And so thank you very much for that. Their attorneys provide legal services, including entity formation, operating agreements, financing, key employee compensation, corporate governance, and the topic of our presenters that they're going to speak about today is intellectual property. And we've got Justin and Josh who are on the screen there, both on the slide and spotlit. So Laura, take it away from there.
Yeah, so we're going to have Justin and Josh introduce themselves when they get into their presentation. They can do a much better job than we can. So we're going to get started with intellectual property control and protection with Weintraub Tobin. I am going to stop sharing my screen so I can figure out how to do that. Let's see, there it is. The colors are blending with my slide. And we're going to spotlight Justin and Josh. Justin, if you want to go ahead and share your screen now, you guys can get started. So one thing we ask that everyone mute themselves during the presentation, except our presenters, of course. If you have a question, we are going to have time for Q&A. If you have I didn't ask you, Justin and Josh, if you want questions during the presentation or if you'd like to hold them to the end.
Yeah, Josh and I discussed that a little bit, and a lot of this stuff is sort of builds on each other and references back and forth. So we're happy to take questions throughout, but it's pretty likely that it's going to be something that we're going to cover in the next slide or something like that. So yeah, we can take questions throughout, but it may just be that comes up later.
Okay, so just so everyone knows how this is going to work, I will moderate the questions. If you have a question during the presentation, post your question in the chat, and then I will either ask the question of Josh and Justin, or we will hold that question to the end if that seems more relevant to me. When we get to the Q&A portion at the end, then we'll invite you to raise your Zoom hand and we'll call on you to ask your own question. So I think that covers all the logistics. If you want to go ahead and take it away, gentlemen.
Sure. Thank you so much, Laura and Jeff, and thanks to StartupSac for having us. As we alluded to a little bit here, Josh and I are going to be talking about startup intellectual property control and protection. It delves into some entity and corporate discussion just out of necessity, but we'll give you guys some background and then start talking about some of the specifics for IP control and protection for startups. So as Laura and Jeff alluded to a little bit, I'm Justin Borrowdale. I'm one of the corporate attorneys at Weintraub. Weintraub is a business-focused law firm. We've got offices throughout the state. Josh and I are both headquartered here in Sacramento, but we do work throughout the state as well. As I said, I'm in our corporate group, and so I focus mostly on entity formation, financing, M&A, securities regulation, and then some commercial agreements as well, like licensing agreements, vendor agreements, that sort of thing. And then I'll let Josh introduce himself.
Hey, good morning, everyone. I'm Josh Escovedo. I'm a partner in the litigation and intellectual property practice groups. So, being a mid-sized firm, we do have a pretty wide range of matters that we handle, as opposed to larger firms who may have a more specific specialty within litigation. So I'll handle general business disputes, real estate disputes, and intellectual property disputes, but IP and real estate are really my specialty. I also handle transactional matters with respect to intellectual property, such as trademark and copyright prosecution, which we'll explain a little bit more later, clearance and enforcement matters.
All right, and then we have to do our lawyerly disclaimer. This presentation, the materials does not constitute legal advice. It does not establish an attorney-client relationship with either Josh or myself or Weintraub Tobin. You can obviously seek us out afterward and get specific legal advice for your situation, and we'd be happy to discuss that further with you. Take it away, Josh.
All right, so we'll get into the substance here. So just to provide a general overview, we'll talk about intellectual property and what that actually is. So intellectual property rights are legal rights that protect original works, inventions, or the appearance of products, artistic works, or scientific developments. And we'll discuss which of those particular intellectual property rights are protected by which different bodies of law. Because if you listen to a layperson talk, you often hear them talk about copyrights or trademarks interchangeably. And while there may be some overlap, generally there's not. And so we'll walk you through the four major types of intellectual property and give you a general overview. So we'll start with patents. And if I sound like somewhat of a layperson talking about patents, that's because I basically am. Patent lawyers are highly specialized and they have hard science backgrounds and things of the sort. With that said, patent is intended to protect patented process, design, or invention for a designated period of time in exchange for a comprehensive disclosure of the invention. So in other words, the government is willing to give you the exclusive rights to exploit a patent for your gain, so long as you disclose everything about that invention, or at least the bulk of the invention. The particular subject matter is codified in Title 35 of the United States Code. On November 29, 1999, Congress enacted the American Inventors Protection Act of 1999, also known as the AIPA, which further revised the patent laws. And so if you're interested in taking a look at that, let me know and we can provide some citations. Trademark, which is, as I mentioned, one of my specialties, is it is a type of IP that is intended to protect your brand. So when we think of trademarks, we think of Nike, or we think of Google, Yahoo, whatever it may be. It is a mark. That's not very helpful. It is a word, phrase, or design for the most part that causes the consumer to associate the product or even just the mark with the creator of that product. So you see Kleenex, you know that it's a Kleenex product. You see Xerox, and Xerox is probably a bad example because Xerox has become genericized, which means, you know, people use Xerox in connection with any type of copy machine or paper, but that's a completely different topic. This was codified in the Trademark Act of 1946, which is better known as the Lanham Act. There are other trademark protections that are provided by the California common law, as well as some state statutes. But when it comes to trademark, mostly people rely upon the federal law, and that's because it has the best and strongest protections. And registration with the United States Patent and Trademark Office gives you rights that span the entire country, whereas common law only gives you rights in the area where you're doing business, and state law only provides you with protection within the state. Next, we get to copyright. So copyright is for original works of authorship that are fixed in a tangible medium of expression. So what does that mean? That means that as soon as your original idea has become manifested in a tangible medium, you have a copyright in that. So it's as simple as something we probably all do on a daily basis, or, you know, most of us, I think. If you take a picture with your phone, you now have a copyright in that particular photograph. If I write down a poem in a notebook, I have a copyright in that work. Now, this is generally covered by the Copyright Act of 1976, but it should be known that even though you actually have the copyright as soon as the work becomes fixed in a tangible medium, it doesn't mean that you can necessarily enforce that right. And so you need to be adamant about recording or registering your copyrights with the United States Copyright Office. And there used to be a situation where you could file suit before having a registered copyright, but now it's been decided by the Supreme Court within the last few years that until your copyright is registered, if somebody infringes your copyright, you have limited rights of what you can do. So for those of you who deal with copyright material or anything of the sort, it's important to register those copyrights, and we'll get into that a little bit more later as well. And finally, we have what is probably the broadest of the intellectual property, of the four primary forms of intellectual property, and that's trade secret. Trade secret can really be anything that is, well, actually, let me start over again. Trade secret protection is only available for business, financial, or technical information. Now, with that said, we can go back to what I was saying before, and it can be pretty broad. I mean, things that have been subject to trade secret in the past include, you know, Coca-Cola's trade secret cola recipe, or Kentucky Fried Chicken's fried chicken recipe. But a trade secret can also be something completely different than that. It can be my client list, for example, could arguably be a trade secret, or who my contacts are, my referral contacts, because theoretically, I believe the test is if it is something that you can derive value from, that could be protected as a trade secret, assuming, of course, it can meet the other rigors of a trade secret. And so my contact list or my referral list could obviously be something that could result in a monetary gain. If somebody else has my list and they're able to exploit that list, obviously they can make money off of it. I mean, same thing with the Coca-Cola example, the Kentucky Fried Chicken example. And I mean, you can get into much more nuanced and scientific trade secrets. I've personally been involved in trade secret litigation where, for example, we were dealing with a matter that was dealing with a biotech company, and they had a device that did, well, I don't want to get too far into the details here, but it had something to do with spinning blood, and it was protected by patent, but it was also protected by the trade secret process because they took significant efforts to make sure that their process was a secret and was held very closely by their internal staff, and that anyone who was exposed to the trade secret information was required to sign an NDA. So, sometimes patent protection isn't available. Like, for example, if somebody takes a product to a trade show before they've actually registered their patent, the patent's no longer available to them because it has been exposed to the public. And once you've brought something out to market or even at a trade show, patent's no longer available to you. On the other hand, you might still be able to protect that product as a trade secret, assuming, of course, it can meet the standards set forth in the law. Like, one of the requirements, for example, that would be pertinent to this particular discussion is it can't be subject to being reverse engineered. You could imagine that quite a few things could be reverse engineered. So when we're talking about that patent realm, sure, you might be able to backdoor some protection through trade secret, but not if the product can be reverse engineered. So that's pretty much the 4 main IP groups in a nutshell.
I think you can tell this is a lunchtime presentation when 2 of your trade secret examples are Kentucky Fried Chicken and Coca-Cola recipes.
Yeah, I think that's right. I mean, I think they're also 2 of the most relatable, right? Because I think
Sure.
If we start talking about, hard science, specialized syringe disposal gear, I think it's a little bit less relatable for most of us.
Right, and I quickly get out of my depth, but the KFC, I'm all on board with that.
Right. I'm all on board with that too.
And so, I mean, the 3 first categories of IP, patents, trademarks, and copyrights, those are all things that you get more protection by registering or getting a patent on because you're putting it out in the world. And so the basic trade-off is I've created some innovation, I've got something that I'm doing creatively here that I want to protect and make money off of, but I'm putting it out in the world, so I need to register it in order to protect it. Whereas the trade secrets basically derive value from being secret and not telling other people about it. So that's part of the reason there's that.
Right. I think that's
different ways to protect things, right?
Yeah, that's a really good point, and a very good distinction to point out between the first 3 and the last. And it's also worth noting that you are disclosing these things to the public or to the government in order to register these marks or copyrights or patents. And that's beneficial to you because, with the patents, for example, once it's out there, it's out there. And if you don't protect it, it can be exploited by anyone. Now, trademark and copyright, as I mentioned, you have some rights in that as soon as you start using it. So it isn't as if somebody can necessarily come along and just appropriate your trademark or copyrights. But as I mentioned, if you solely rely on common law or state law rights, for example, and I'm using a particular trademark, somebody that's over in New York, if I don't do a federal registration to obtain nationwide rights, somebody over in Florida or New York can come along and say, hey, I like that trademark, I'm going to use it here. And then they might register it. And my rights would be limited to California, for example. And now the person who I just gave my idea away to has the rights in the other 49 states.
Right. Yeah. So I think as you'll see as we move through some of this stuff, this can get complicated and sort of interrelated pretty quick. With Josh's example there, even if you come up with the IP first, that doesn't necessarily mean that you have worldwide or even nationwide rights to it. So this stuff can be really important to work through for your company. So I'm going to move over to the first sort of general category that we want to talk about for IP here for startups. So I've sort of separated things out into different categories. I've got founder IP and then employee and independent contractor IP. We sort of differentiated those because of some of the factors that go into basically when that IP is discussed and when it's used. And then just everybody's, I guess, outlook on the IP and their perspective on the IP that's going to be discussed. So separated those out, and we'll cover those separately. So at the founding of a company, a typical startup scenario, you've got 3 friends in a garage that are going to start a company or something like that. A couple of different categories of IP to consider. So the name itself might be something that's part of your intellectual property, might be a trademark. Josh mentioned Nike. Obviously, that's a brand that's got just the name itself has value. I know I've got a bunch of shirts that are just t-shirts, but they say Nike on them, so I paid more for them than a regular white t-shirt. And then one of the things to consider when you're coming up with something like that, like your name or potentially like a tagline, is to potentially do a trademark search. You can do some decent research on Google, just seeing if somebody in New York or Florida uses something similar to you. But a full trademark search would probably be helpful in that sort of situation, to make sure that when you put all of this stuff on your website, on your emails, when you sort of form this company, that you're going to be able to use that name, that tagline, the way that you're anticipating you'll be able to. Josh and I worked with a client who had sort of I describe it as like a lifestyle brand, sold apparel, and he used a popular hashtag from Instagram on some of his apparel. And so that became part of his brand identity and sort of a tagline for him. And the reason Josh and I got involved, unfortunately, was he got a cease and desist letter from somebody who owned the trademark for that hashtag, for the phrase that was used in that hashtag. And so we sort of entered into some lengthy negotiations with the other side, trying to figure out some solution where our client could use the trademark. It ended up basically not working. He had to pivot a little bit, but so he had to take the apparel that he was using that trademark on. He had to take that off his website. Certainly lost sales from that. He had to come up with a new tagline, something else to put up and sort of replace it. And then of course, Josh and I we're attorneys, and we're good at what we do, but we are also expensive. So, significant attorney's fees resulted from that lengthy negotiation, and unfortunately, we weren't able to, come to a solution where he could continue using it. And so it's an unfortunate situation that could have potentially been avoided, if he had done that trademark search and saw that, hey, actually somebody owns this trademark already, and so I should either talk to them at the beginning to work out some sort of license, or maybe I should come up with a different idea before I spend all this time and effort, building up my apparel, building up my brand based on this phrase. Some other categories to consider when you're thinking about this stuff is potentially a logo. Again, the Nike swoosh, a great example of something that's just a symbol, but having that again on your t-shirt, on your tennis shoes, means something to a consumer. Then of course, for startups, technology, software, an app, any of those sorts of things are also IP that you want to consider, and just think about how to deal with when you're starting your entity. So what that looks like for a typical startup in this founder environment. So like I said, we've sort of taken a typical situation where you've got maybe 3 friends in a garage that are going to be typically forming an entity. They come together as 3 individuals with an idea, and then they want to flesh it out and have an entity. And that gives them some benefits in terms of course, limiting liability. It helps govern the relationship between the parties, because the different founders may have different things that they're contributing, different roles in the company, and so it helps govern that. And then of course, it helps govern the IP ownership and use among the parties. Because basically, when these 3 individuals come together, they're going to have their own ideas and own contributions that they've made to the IP. But basically, once the entity is formed, that's going to be the the entity's IP. It doesn't belong to these individuals anymore. Some of you may remember Mitt Romney got in trouble when he was running for president for saying that corporations are people too, which may not be a good political statement, but makes sense in this legal context, right? The entity is going to be sort of its own person from a legal perspective that's going to hold this IP.
So, Justin, there's
yes.
been quite a few questions in the chat. I asked Josh to review them to see if there might be some that we should answer now rather than hold till later.
Okay. Yeah,
Josh,
I thought there were a couple that warranted, and that's not to say that the others don't warrant being answered, but I mean, I think there are at least 2 or 3 that are going to be covered in the next couple of slides, and so we can always come back to those if we don't answer those questions entirely. But I see the URL question, for example. I mean, well, it says curious about URL ownership. It's not necessarily a question, but I can give just like a brief overview of that. URL ownership is a little bit different than trademark ownership. Just because you have the rights to a particular phrase or mark, it doesn't necessarily mean that you have the exclusive right to have that URL or domain. You know, with respect to the domain, there could be somebody else, and maybe it warrants taking another step back in terms of trademark use and what rights you actually have. But when you have the rights to a trademark, you don't have the rights to utilize the mark, design, or whatever in connection with everything under the sun. Your rights are limited to the goods and services that you provide and those that are within the reasonable zone of expansion from those particular marks. Aside from that, you know, you can't, for example, Nike can't stop an insurance service provider from using the word Nike, at least as far as I'm aware, because I don't think that Nike is in the insurance game. I'm pretty sure that they have no plan to do so. It certainly isn't in the reasonable zone of expansion from shoes and athletic apparel. But that's just one example. And so I actually have a client right now who has a production company, and she really, really wants the name of her production company.com, but that particular domain is not available. And the guy who has it has just been sitting on it for 15 to 20 years. And there are certain mechanisms through which you can challenge somebody holding possession of a URL hostage, but you would have to be able to show that they've had some sort of bad intent and that they're technically cyber squatting. Just because somebody owns it and isn't doing anything with it, that's not sufficient to obtain ownership of that particular domain under the law. So once you have the rights, you know, certainly you have somewhat of a broad expansion, and you can't just go get a confusingly similar name to mislead consumers. Like, for example, I know that I was recently looking at some apparel by Off-White, if you're familiar with the brand. It's Virgil Abloh's brand. And I was on my phone looking at shirts, and I had been on my desktop earlier. And when I was on my phone, I realized that the shirt was about 1/6 of the price of what I was looking at on my desktop. And so I went ahead and scrutinized the website, and I realized that the website was offwhites.com instead of Off-White. Now that is a trademark violation. That is somebody who is attempting to sell the same sort of goods and services that you are by utilizing a mark that is confusingly similar to your mark. Now that is an example where you can protect your domain, but as I said earlier, just because you decide to start using a mark, it doesn't mean you're going to be able to come along and take a domain that somebody else has already acquired earlier on.
So I scrolled through a little bit, but were there other questions you thought we should cover now, or some stuff is going to be later on?
I think that a couple of the others, or 2 or 3 of the others, are going to be covered later on. The only other one that I think I would touch right now would be the request that we go a little bit deeper in terms of reverse engineering. You know, if we're talking about a topical with several ingredients, which is what's mentioned in the chat, you know, it really depends upon what sort of mechanisms they can use to actually derive what you're using in that product. I mean, if you can really just piece it apart using some sort of process, then that's technically capable of being reverse engineered, and they could obtain the rights, or not necessarily obtain the rights, but they could then use that product because it wouldn't technically be a trade secret. Now, if
we're actually directly extracting from plants, and some of the solvents we're using are removed before the final product. So that part wouldn't be apparent. but I could only, I would only be able to protect that part of it, right? I wouldn't be able to protect my ingredient list as a result of that. So that's kind of what's going on.
Yeah, so I think with something like that, you wouldn't necessarily be able to protect the ingredient list just because that's something that they're capable of deriving through their own process. But if they're incapable of discerning how you're obtaining those solvents or what you're doing in your process, then I think the argument can be made that the final product is still protected as a trade secret, because the final product is derived through that process that you're saying they wouldn't necessarily be able to figure out through a reverse engineering process. And so I would say that that particular aspect is integral to the final product. And so the final product would technically still be a trade secret.
As would the process itself, right?
Right.
Thank you.
Yeah.
Thank you very much. And the ingredient list has to be published on the product anyway.
Right,
The
right.
FDA. So you know,
Yeah.
that's.
Yeah, and as we sort of alluded to, right, the trade secret obviously derives value from being secret. So if you like in this scenario, if you have to publish the ingredient list, that's obviously not going to be a secret, but the proportions and all that, yeah, and the process, yeah. Okay. All right, so I'll jump back in here to the founder IP. So when these founders are getting together, and they're going to be contributing ideas. Maybe somebody's started some software and you've worked out some stuff. Sort of depends on where you are in the process. But when you all come together and you're going to form this entity, usually there's a stock purchase agreement, maybe a contribution or organization agreement, some sort of assignment agreement. But that's the document that usually in this sort of scenario, you're going to contribute that IP, that idea, that software, whatever it is. You're going to contribute that to the entity that's being formed. And in exchange for that, you're getting shares of the company. So it's usually that IP, maybe a little bit of startup money in there to pay the attorneys. But it's usually based on that IP, whatever the idea that you're starting with. And so you want to make sure that everybody understands sort of the relative rights and responsibilities. If everybody came up with the idea together, then you're all sort of contributing your in my scenario, 1/3 of the IP to the company, and moving on from there. And usually in these founder scenarios, everybody's the sort of typical situation is the founders are dedicated to the company. They really want to make this work. This is probably a full-time job, if not more than that. And so there's usually not too much issue in that sort of co-equal scenario with the founder contributions. And like I said, that's done through a contribution agreement. But there are a number of other scenarios that are maybe atypical, but certainly come up very frequently. One of those could be where maybe one of the founders did most of the IP on their own, and they're coming together with some other individuals that have other complementary skill sets. And so that one founder is going to be contributing maybe a portion of the IP that they've created to the company. So a good example of that maybe would be if you've got some software and you've got, I'm going to use my hands here, but sort of level X of software, and then the founders got some Y on top of that that's not going to be contributed. So they contribute the X amount of software to the company. The plan is for the company to develop that further, add Z onto it, and then they're going to have a new product, a new app, something like that. You have to look at the relative, like I said, the relative relationships between the parties, because now obviously it's not founders contributing everything they have in this idea to the entity. This founder is going to be holding back X, that amount of, you're going to be holding back Y. They're going to be potentially using that for other business purposes. In that scenario, if they're contributing the base level of the software, they're going to need a license back from the company to continue using it if that's what they want to do. And you have to start looking at whether or not that founder has the right to compete with the company, to license this stuff to other people, or if it's exclusive to the company. And then just on a fundamental level, that obviously puts the company in a different position against this founder, right? There's sort of competing interests there. that weren't there before when everybody was sort of on the same page and all contributing everything to the company. So there's quickly can be some complexity that gets added to this founder scenario. And then the another scenario is sort of similar, but brings up some different potential issues. Would be if the founder that's contributing this IP, potentially they don't contribute the IP itself at all. Maybe they contribute just a license to use the IP to the company. And that's the contribution that they're making, just that license, as opposed to ownership and control. And so there's, again, some similar issues that come up, but sort of some different nuances on it. You'd have to look at, the company's not going to own that anymore. So you have to look at where else the founder might have licensed that IP and who you'd be competing against. Again, if it's exclusive to you, what rights you'd have relative to these other people. And again, you're sort of looking at, not control, not full ownership. And so you're going to have to negotiate that license and figure out, make sure that the company can use it in the way that it wants to. It can develop its own IP and add on to it and figure out who owns that developed IP sort of on down the line. So yeah, typically there's these is sort of an easier founder situation, but again, it can get complicated pretty quickly. And this is all basically just at the beginning of the entity formation. This is all from the get-go. As the entity continues on, the founders may just participate in the company as shareholders, just as owners. They may and probably likely also participate as employees and officers of the company. And so as they're continuing to develop the IP, as they're continuing to do work, do research, you're going to want to have, the company's going to want them to have maybe an employment agreement, usually what we call a proprietary invention assignment agreement. There's some other variations on that name that are used. But that agreement basically protects everything from the founding forward that these founders would work on. So it generally requires the employee, the founder, to maintain the company's non-public and proprietary information, sort of protect their trade secrets. And then it also requires the employee to contribute whatever it is they're creating, discovering, developing, inventing, all of that. While employed with the company, they contribute that to the company sort of on an ongoing basis. Are we doing good with questions?
We haven't had a new one
Okay.
since there's still some that we haven't answered, but we're holding them till later.
I
Okay.
think they're going to be answered on the very next slide, actually.
Okay. Yeah. Perfect. Yeah. So next we've got employee and independent contractor intellectual property. And so like I talked about, the reason for some of this difference between the founders and the eventual employees and independent contractors, obviously the employees and ICs aren't going to be there at the founding. So they're going to be contributing stuff that's after the initial contributions. And then just as a general perspective, these folks may be involved, may really care about the company, but it's likely that they don't have that same level of interest and involvement as the founders do, right? Just by the nature of the relationship and how this is all progressed. And so that changes the dynamic a little bit between the individual and the company. Changes everybody's perspective on things. An employee is often going to be a full-time person, but an independent contractor is probably working for other people, maybe has their own business that they've got interests in and want to keep IP with, likely doing something similar, whatever service they're providing for your startup, likely providing that for other companies as well. So those considerations are just basically going to be different. So with an independent contractor, the default is basically that they would retain the ownership of any IP that they would create. And that's true even if it's, if I'm the startup and I ask Josh to make me an app, the default is that Josh would own the IP in that app, even though I've asked him to make it. And so that's the reason that you have an independent contractor agreement, you have an invention assignment agreement, is that's the device that sort of transfers the ownership from the inventor, the one actually doing the work, to the entity. Yeah, patents are owned by the individual inventors or the inventor. This would apply even when an inventor conceives an invention or reduces it to practice in the course of its employment. Again, that's sort of overridden by the employment agreement, the invention assignment agreement. That's also true of copyrights. There's a slightly different definition that you work with for a copyright. The work has to meet the definition of a work made for hire, basically, which is the concept there is, again, similar to what we've talked about, that the employee is the one creating this, but they are doing so for the benefit of the entity. And so the contract, again, would override and sort of move that ownership and control from the creator, the individual, to the entity. To flesh that out a little bit more, a copyrightable work has to be specially ordered or commissioned from an independent contractor, and the parties have to have agreed in a signed document that it's a work made for hire. And then there's a number of categories that would have to fall under. So it has to be a contribution to a collective work, a supplementary work that is prepared for publication, a compilation, instruction text, test, materials for a test. There's an atlas, a couple of other odd ones, translation, motion picture, or other audio visual work. But basically the contribution to a collective work is likely, or potentially supplementary work, is going to be the thing that usually you're going to rely on in this sort of scenario. The independent contractors providing some aspect of a copyrightable work, but it's part of this larger project that you're working on. So similar with trademarks, individual creator, they're the ones that own the trademark unless it's subject to this agreement. Trade secrets are a little bit harder, just by their nature. It's hard to create a secret. So that concept is a little bit wishy-washy, but again, sort of try to protect those through these contracts where the individuals are contributing that over to the entity. And that's, like I said, generally through this proprietary invention assignment agreement, similar to the founders. This is going to require that the employee maintain the non-public and confidential information of the company, and it's going to require them to contribute the stuff that they create, discover, develop, or invent while employed with the company. And like I alluded to before, the relationship here is fundamentally different than with the founders. So, if it's an independent contractor, like I said, they've likely got their own business. Maybe they have their own IP that they're worried about, that they're trying to protect. And so exactly what it is that's being contributed is much more likely to be heavily negotiated and fought over between the entity and this independent contractor, because the roles are different, right? The independent contractor wants to keep as much as it can because that's part of how it's developing its business, likely, and the company has the opposite perspective and opposite goals. For an employee, again, sort of similar analysis, but likely the employee is more involved with the company, right? Generally a full-time person, so they're less likely to have these separate business interests. But they may have come from another startup or another sort of IP heavy company, and so you have to look at, when you're hiring these people on, you have to do some due diligence on that front as well. So as part of these agreements, there's going to be a schedule in the back where you declare what IP is not being contributed and what is not going to be owned by the company. Basically, that's something that you had either done beforehand that's sort of relevant to the work that you're going to be doing, that you want to have excluded. So, if I'm developing some software for Josh's company, but I've done something similar either on my own or for another company, that's something that I'm going to list there. And basically, the goal here is to have some open communication between the employee and the company. Basically, I'm going to tell the company, hey, this is something that sort of falls into the category of what we're talking about, but this is either mine or it's my other entities, and so this is not going to be contributed. This is not coming over to the company. If you want to use it, then you can enter into a license agreement and you can deal with it in some way, but it's not moving over as a function of this overall assignment agreement. And then, so another aspect of that to be concerned about from the startup perspective would be to make sure that whatever it is that is supposed to be coming over from the independent contractor or employee, whatever IP they're supposed to be contributing is actually theirs. If they entered into a similar agreement with their previous employer or another company they worked for, maybe they don't have the right to contribute this, to assign it over to you, because it's actually held by that other company that they were working for. So this is all sort of a discussion that you would need to have between the entity and the person that you're hiring on, to make sure that everything is assignable, is transferable, and that everybody at the end of this, walks away with the things that they want in terms of IP ownership and control.
So Justin, are you going, someone asked about being a student at a university and making it so the university didn't own the intellectual property. Are you going to address that later, or is that something you could address here?
Yeah, so we have some later on. We have some what we've labeled as infringement tests, and that's going to cover some of how the different rights would be apportioned. For university specific things, I mean, I haven't dealt with, usually we're dealing with private companies and employers, which have sort of different relationships. So I haven't done anything with universities in general. But my understanding is that for the most part, you're using the university's resources, using their their databases, their equipment, all that sort of stuff. So they're likely going to have heavy IP rights in whatever it is that you're creating. Especially as a student, I'm not sure what negotiating power you would have in that context. I know it's a little bit different if you're an employee or a researcher. I know those things are often, like I said, heavily negotiated. I had a friend from law school that worked in UC Davis's sort of in-house counsel role, and one of UC Davis's most valuable assets is their IP ownership for basically the strawberries that you see in grocery stores, the sort of big red ones that taste decent but keep really well. That's generally a UC Davis patent that they have, but it's obviously developed by somebody that works for the university, not the university itself. But that's obviously something that's going to be negotiated and fought over. I don't know if you've run into student work at all, Josh, and how that relates.
I mean, I've read about it and seen situations that have arisen, but generally what you see arise is a dispute between a researcher or professor and the university concerning who owns what. But for the most part, with respect to the students, if the students are utilizing the university's resources and everything else, it's likely that the university owns it. I would think that would be in the student handbook or some other source, something you sign once you are actually utilizing the university's resources. Because, I mean, I suppose, code of conduct is where it could also be. I mean, I guess if you were a student that came in and you were, Spiegel coming into Stanford, let's assume he had the idea for Snap before he got there. I mean, presumably you may be able to enter into some sort of negotiation with the university and have some sort of leverage. But I mean, your average student who isn't coming to the university with significant leverage, I mean, the university is just going to say, this belongs to us. You use our resources, it belongs to us. It's as simple as that. But I mean, I guess the only thing I could say is in terms of protecting yourself in that situation, you may not be able to negotiate or obtain the rights if you're going to use the university's resources, but you can at least have a firm understanding of what your rights are by making sure that you ask questions as to where you can find resources regarding the university's policy on intellectual property development, read through the handbook, read through the code of conduct, and all of that stuff. I mean, I think that is definitely how you could ensure that you at least have a firm understanding of your rights.
And I was thinking about it a little bit. Again, this is in the sort of researcher context, but I've seen a couple of it's basically licenses that result from this sort of arrangement. But I've seen some universities that would allow the actual inventor, the creator, to use their IP however they want, but they also grant the university a license to do whatever they want with it. So, you know, if it's a UC Davis and it's a plant patent, you know, they may very well go ahead and use that and do something with it. But if it's, UC Davis maybe doesn't do anything with software, say, you develop some software, maybe there's a license that sits out there that UC Davis is allowed to use it, but they don't actually ever do anything with it because that's not really their focus. That's not where they are putting this effort. But yeah, I think that's all good points. It's a lot of this is it's legal and it's contract negotiations, and it's important, but a lot of it is also to facilitate a discussion and communication between the parties. Because the goal here, right, is so that everybody understands what's going on, everybody understands who owns what at the end of the day, as opposed to trying to sneak something from somebody else. The idea here is to avoid litigation and to flesh all this stuff out beforehand, so that people know what they have and what they don't have. Okay, so I think that's all I had on employee and independent contractor. So I will turn it back over to you, Josh.
Okay, so we'll get into the intellectual property protection now that we've provided a general overview of each one of the primary 4 intellectual properties. So we'll start with patent. And again, just bear with me on this. I'm not all that familiar, but patent prosecution is the first step in obtaining the protection. And so in order to be able to protect your patent, you need to apply the United States Patent and Trademark Office, specifically the Patent Office, and seek a patent. And a utility patent covers any new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvement thereof. A design patent, on the other hand, covers a new, original, and ornamental design for an article of manufacture. A plant patent covers, invents, or discovers and reproduces any distinct and new variety of plant. And these patents last for 20 years. Copyright protection is sought in a similar manner, but that's done through the United States Copyright Office. Copyright in the United States, as I mentioned earlier, protects original works of authorship from the time the works are created in a fixed form. An application for copyright registration can be submitted online to the United States Copyright Office. Although registration is not required for protection, at least, I think that's probably a little bit of an overstatement. It is required to actually protect and police your rights. It's not required for you to obtain rights, but as I mentioned earlier, a Supreme Court case recently came down and said if you haven't registered your copyright, then you can't prosecute an action for copyright infringement. So yeah, you still have the rights, but you can't really do anything about it until that copyright has been registered. So not only that, but then you also obtain a number of rights and remedies under the Copyright Act. It's also helpful when you have the registration with the Copyright Office. It provides some sort of constructive notice to others that copyright is out there. And it also creates another issue where if you get into litigation, and this applies in the copyright context and the trademark context, perhaps even the patent context, but once you start, one of the material elements that you'll have to establish in your claim is that you have a valid trademark or a valid copyright. Well, if you have a registered copyright with the United States Copyright Office, the law presumes the validity of your copyright. And so then the burden is on the other party to try to disprove that you have a valid copyright. The registration also provides you with a couple of other important remedies, and that is specifically it provides statutory damages, which can be pretty significant because, as you can imagine, with copyright, just because somebody infringes your copyright, it doesn't necessarily mean that you're going to be able to definitively or easily quantify the damages that you've sustained. So when you have statutory damages, you're able to say, you know, I can't really quantify my damages. I may not have even been damaged specifically, but because the Copyright Act says that I'm entitled to $750 to $30,000 per infringement, I'm entitled to those damages. So that's another significant benefit of the Copyright Act. And then, of course, the right to recover your attorney's fees, because that's a huge deal, especially in the startup world, because you're trying to spend your money on building your company and advancing its interests and scaling. You're not trying to necessarily spend $500,000 on attorney's fees. Of course, if you are, please make sure you get my number, my email, and you can get in contact with me after this. I'm here. But most of you are not trying to spend money on that sort of thing. I mean, it just eats up everything and it stifles the development of the company. So it is helpful when you have a mechanism that provides you with a means of obtaining your attorney's fees and costs as an award, because otherwise you can spend $500,000 on litigation easily, and you might get a $200,000 award, which may or may not be collectible from the party who you've obtained the judgment against. And then let's even say it is, you get your $200,000, you spent $500,000, now you're $300,000 in the hole. That's not a good outcome. It does happen, of course, but here you would have a right to recover your attorney's fees and costs under the Copyright Act. And the same can be said for the Trademark Act, except for the Trademark Act is a little bit stricter in terms of when you can recover attorney's fees. And speaking of saving costs, this another interesting development and certainly worth knowing when you're just getting your business started is that the CASE Act, which was passed in connection with the COVID stimulus bill in December of 2020, has actually created what we'll just casually refer to as a copyright small claims court. And so that is for claims, I believe, under $30,000, and that will be formed by the end of the year per the act. And I think, you know, that creates an opportunity for startups or even artists, because, you know, artists aren't always completely flush with cash, nor do they want to spend cash on infringement actions unless they have to. So this creates a nice alternative venue where you can litigate a copyright claim and actually vindicate your rights without having to cash out with $500,000 or $200,000, whatever it may be. So that is definitely worth noting. Trademark registration is like patent done through the United States Patent and Trademark Office. And something that's worth noting with respect to trademark law generally is that even though registration is vital, and I can't stress that enough, if you have a trademark, it is important that you get it registered as soon as possible. The United States is not a first to register country. And what does that mean? That means that it's not the date of registration that necessarily matters. What matters is when you first started utilizing the trademark in connection with your goods and services. And that's because that creates a priority over others who subsequently use that mark. So let's say that I have an e-commerce site and I ship nationwide. And we're using that as an example because, as I mentioned earlier, common law rights are restricted to the area you're doing business. And I want this to be as simple as possible. So let's say I ship nationwide, so my rights span the entire country. If I started using Weintraub in connection with my e-commerce store in 2010, my rights would relate back to 2010, even if I registered today for 2021. And the same goes for other situations. So if you start a company, you don't do the clearance search that Justin recommended earlier, You just try to register your trademark. Let's say it does register because someone else hasn't registered theirs. But let's say that they've been operating an e-commerce store selling the same types of goods and services as you, and they've been doing it for 10 years nationwide. Even though the United States Patent and Trademark Office is quite possibly going to register your mark because they're unaware of that other store, that other party can then learn of your trademark and go file what's called a cancellation action in the United States Patent and Trademark Office. And if they can establish that their rights or their priority predates yours, the USPTO will cancel your trademark. So imagine that you've been using this trademark, you've been building goodwill in it. If you're Nike, you've been spending millions and millions of dollars on your trademark. And now somebody comes along and cancels your trademark and you can never use it again. That's a pretty devastating hit. And so, I mean, it really just stresses the importance of running a clearance search, which is where you go to an attorney or you hire a trademark search service and you say, run a search for X mark. I want to see everything that is even remotely similar. And then hopefully, you know, you consult an IP professional and they take a look and tell you, because it's not always readily apparent what is or isn't confusingly similar, or even beyond that, what a United States Trademark Office examining attorney might think is confusingly similar, because what's actually confusingly similar and what the examining attorney thinks is confusingly similar can be quite different. So it's important to have an IP professional's perspective on it, because they can tell you, you know, even if this gets flagged by the PTO, hey, I think we can push back and actually get your trademark registered. And so as with copyright, the registration with the Trademark Office comes with significant benefits. It provides treble damages, which means like triple to quadruple damages, possibly double, you know, just depends on how significant the bad intent of the other party is in ripping off your goods. It provides the possibility to recover attorney's fees and costs. One of the most important cost-saving mechanisms is once your mark is registered with the USPTO, then the USPTO serves as sort of a guardian of your trademark, because when somebody else comes to register a trademark at a later date, the examining attorney will do what they once did to you, and they'll look at the new mark and say, is this confusingly similar to any other mark that we have registered in our database? And if it is, or they think it is, they'll issue an office action and they'll tell the other party, look, we're not going to register this mark because it's similar to another mark. Obviously, the benefit there is you're not having to then sue that party for infringing your trademark, because hopefully the USPTO has backed them off of using it. And now, although not always, they're not going to continue to use the mark, and therefore you saved costs of litigation. So that's a pretty significant advantage as well. With respect to trademarks, they last as long as you can maintain the registration. There are certain periods you have to file a number of different statements. You have to file a statement of use after 5 years. You have to renew your trademark after so many years. And but that's another thing that's important about having an IP professional is you get an IP professional that gets all of this information calendared so that you don't necessarily have to worry about it. And they can make sure that all of the filings are made to ensure that your trademark isn't abandoned. Now, there are ways to deal with abandonment if it happens, assuming you catch it early enough, but you don't ever want to be behind the 8 ball and have to explain to the PTO why you accidentally abandoned your mark. Plus, I mean, I think you as a professional or a business owner, you don't really want to be in that position where, you know, you had one of those oops moments and you're having to dig yourself out. So that's trademark registration. And then trade secrets. I mean, really what you have to do with trade secrets is you have to take reasonable measures to ensure that the confidentiality of that particular trade secret is maintained. So long as the owner is deriving independent economic value or a business advantage from that particular trade secret, then it is a trade secret and you can protect it. But if you don't take the reasonable efforts to preserve the secrecy, you will lose the trade secret. And so, you know, if somebody misappropriates your trade secret, let's say somebody works for you and they leave, and now your competitor all of a sudden, just by sheer coincidence, hired them and they have a competing product, and it's very similar to yours. You are probably going to sue them for trade secret misappropriation. And one of the things they're going to say in defense is that it wasn't a trade secret because you didn't take reasonable means through which to preserve its secrecy. Now, of course, hopefully you will take our advice and you'll make sure that, well, I'm sorry, you will, I don't want to say advice here, you will heed our warning, let's say, and you'll do the right thing to protect your trade secrets. And so you'll be able to fight off that defense. But otherwise, you know, you do have situations with some companies where they turn around and say, well, you didn't take reasonable measures to preserve its secrecy. And then you get into discovery and you find out that this company didn't even require its employees to sign NDAs. Well, I'd say that weighs in favor of a potential finding that they didn't take reasonable efforts, because anybody who's dealing with trade secrets should probably have NDAs and whatever else in place. And so that's really how you have to go about protecting these trade secrets. And the law is not stagnant. I mean, it's a little bit of an amorphous concept, because depending upon what the trade secret is, the reasonable efforts to preserve its secrecy are going to differ. I mean, you know, it's going to be different for a client list than it's going to be for some top secret formula of some sort. So just something worth keeping in mind. So from there, we can move on to the infringement tests. And so we've talked about what the different forms of IP are. We've talked about how to go about protecting those, the IP. And now what we can look at here is, assuming you get into a dispute, whether you're on the defense or on the plaintiff's side, what are the tests for infringement? And so for patent infringement, you have the ordinary observer and the incorporation tests. Essentially, to be liable for patent infringement, you have to have made, used, sold, offered to sell, or imported an infringing invention or its equivalent. For a design patent, it has to be substantially the same through the eyes of an ordinary observer familiar with the prior art. And when we say art here, it's a term of art referring to the design patent. With respect to a utility patent, the test is whether it incorporates a patented invention without authorization, and that is the incorporation test. The copyright infringement test is the substantial similarity test. And copyright infringement occurs when a copyright is reproduced, distributed, performed, publicly displayed, or made into a derivative work without the permission of the copyright owner. That's the bundle of rights that emanate from a copyright. And so what the court does is it has a two-pronged test where it evaluates whether the use or whatever the work is substantially similar to your copyright. Of course, there are some exceptions for copyright because we do want to encourage creation. I mean, that's part of the reason these tests, or that's part of the reason that patent law, for example, gives you this exclusive protection, but requires you to disclose everything that you've done, because we want to promote innovation. And so with respect to the arts, you know, we want people to come up with similar ideas, but not infringing ideas, but we want people to build on those. And so we've made exceptions in the law for what's referred to as fair use. And fair use exists when there's criticism or comment on an original work, reporting, scholarship, teaching, or instruction. So, I mean, that's how you see educational institutions get away with using certain parts of copyrighted works without obtaining a license, as they're using it for a teaching or instruction purpose. Same with the news. When the news is reporting on something, and you also see this quite a bit on YouTube now. I mean, just to kind of bring this to a modern example, you'll see a YouTuber. I know, for example, I represent a YouTuber, and she went on a television show, and this is all really vague and intentionally so. She went on a television show and she got absolutely ripped for what she does on her YouTube channel. She then went and did, of course, her own YouTube video where she basically reposted the entire show, and she walked through how they had edited it to make her look as bad as possible. They pushed back on her and said, hey, that's copyright infringement. You're using our show. We said, actually, this is fair use because this is absolute criticism of your copyrighted work and how it was done. And they said, all right, yeah, we're not going to touch it. Then we're going to leave it alone. Another pretty mainstream example is when you think about like Weird Al songs. Obviously, a lot of Weird Al Yankovic songs are copyright protected works, but his songs are parodies of those works. And so because that's the case, you know, he can change little things here and there, and it still passes muster under the fair use examination, and it doesn't result in an infringement because fair use is by definition not infringing. Trademark infringement utilizes the likelihood of confusion test. And what that does is it uses a number of factors, and it differs depending on which federal district you're in. Here in the Ninth Circuit, which is where California sits, we use what's called the sleek craft factors. And there are 9 factors that we weigh, such as whether there's been actual confusion, whether the goods and services are similar, what channels of marketing are utilized, and you basically balance all of these factors and you say, is it likely that a consumer would a reasonable consumer be likely to be confused about an association or endorsement of those two products? And if the answer is yes, then the likelihood of confusion test is satisfied and there has been a trademark infringement. That, as just like it sounds, I mean, 9 factors, it can really get complicated, and there's never a clear answer in trademark infringement litigation. I mean, there's always 3 factors going one way, 5 factors going the other. The only really clear-cut, well, I don't want to say the only, there are plenty of clear-cut cases, but I mean, the worst are just when people are blatantly trying to rip off a trademark, like, Justin's Pepsi. That's obviously an infringement of Pepsi. Something like that would be absurd. But aside from that, things that sound similar, but they're on goods that are pretty different, then you have to weigh that process. And then, of course, there's another aspect to this, which has been publicized a pretty good amount in the last 12 to 18 months. And prior to that, I hadn't seen a lot of this, but there is a body of law that basically says you can utilize a portion of a trademark or a trademark phrase or logo if it is for an artistic purpose. And that has been the subject of scrutiny recently. I wouldn't be surprised if we see the Supreme Court take that up at some point. But it's worth considering, because essentially what the courts have said is, if there is even an ounce of artistic purpose here and the use is not intentionally misleading, it's fair game. And as you can imagine, the companies don't take too kindly to that. And most recently, it was Jack Daniels who was on the other side of an infringement action that they brought because somebody created a squeaky dog toy called the Bad Spaniels Squeaker, which was modeled after a Jack Daniels bottle. Apparently, they were upset and thought that people might think that Jack Daniels was in the squeaky dog toy game now, but the court wasn't buying it. So just a little bit of information for you on that. With respect to trade secret infringement, really the test is, first, whether there was a trade secret. I mean, that's the threshold question. Is there a trade secret, and was it properly protected? And then if it was, the next question is, was it misappropriated by the party? And obviously that can have a number of factors or facts that are built into that. Like, for example, how was it misappropriated? How did this person ever come in contact with the trade secret information? And obviously in the abstract, that sounds like it could be a lot more complicated than it really is, because in the real world, often we have a former employee who's gone to a new company. Well, it's obvious how they were ever exposed to it. They were at the company where the trade secret was utilized. And so then the question becomes, was it misappropriated? In other words, did they have a right to do what they did by taking the trade secret and utilizing it elsewhere? And if you've done what we've mentioned during this presentation, and you've taken prudent means of protecting that information with NDAs or any other type of agreements, the answer is probably going to be yes, that they did misappropriate that information. But it is a test that can be, it can kind of go both ways depending on what facts are present on any given situation. But again, the run-of-the-mill test, former employee leaves company A, goes to company B. Company B now has a strikingly similar competing product to company A now. I mean, that's probably a pretty clear-cut case. And that's not to say it won't be a costly piece of litigation, but that's probably the best example of a trade secret misappropriation.
All right, I think we're getting close to the end here. I think Josh and I have one more sort of example case study to talk through with you guys to sort of bring some of these concepts home. This particular one has to do with a trademark. That's an easier one to understand and sort of gets more reporting than some others. But this is a local case that I think Josh did a little write-up on it, and I followed in the news a little bit just because I thought it was interesting. And it's a good example of some of the competing priorities and just the way this stuff works out in the real world. So some of you guys might be familiar with the Firestone Public House, which operates a restaurant in Sacramento. And then Bridgestone Brands owns Firestone Tires, which is been around for 100 years or however long it's been, for forever. So I'm just going to refer to them as Tires and Public House for ease of reference here. So Tires sues Public House for trademark infringement over the use of the name Firestone as part of their restaurant. And so that's sort of the headline that first gets reported. And that sounds like a big international corporation is being mean to the nice little restaurant. They're being overly aggressive. And it seems like, screw Bridgestone. I like Firestone Public House. They should win this case. And then sort of going back through some of the concepts we talked about, the tire company, they have a duty to police their trademark, or they risk it being diluted, canceled, genericized, like Josh talked about with Kleenex and Xerox. So they have an obligation to go around and basically try and prevent other people from misusing their trademarks. They may not always win every single case, but they've got that affirmative duty to go out and do this policing. So you can sort of excuse the big corporation for doing that in the context of what's required by them under trademark law. So then if you apply some of the principles that we talked about, right? A restaurant and a tire company, vastly different industries and businesses. So even if the tire company is policing their trademark, there shouldn't be a likelihood of confusion, right? Why would I think that a tire company has opened up a restaurant? And so, yeah, that's sort of the general thought that you would have. But as maybe you've gathered here, and I think we should probably hit a little bit harder, a lot of this stuff is very fact intensive. It depends on, there's factors and things that you weigh in terms of legal standards and analysis, but a lot of it depends on what's actually happening and the facts on the ground, as it were. So in this case, the Public House is operating a restaurant in a location that used to be occupied by a different business for about 75 years before it opened as this restaurant, and it was a Firestone tire shop. The building it's located in is even sometimes referenced as the Firestone building when people are talking about it. So the Firestone Public House obviously was aware of this, and potentially to some degree was trying to trade on that history and that legacy. And so the fact that they were operating in this space that was a Firestone Tires and is sometimes called the Firestone building certainly makes it more likely that there's a likelihood of confusion in this sort of case. A couple of additional facts that color this even more. Firestone Tires actually does operate a restaurant within a country club that uses the name Firestone. I'm not entirely sure why they do that, but I'm assuming it's some sort of weird old money thing that I'm not privy to because I'm not blue blood enough. But yeah, they do have this restaurant, and they actually do have a registered trademark for the use of the name Firestone in connection with restaurants. So this is just a good example of some of the back and forth and how the facts on the ground really make a difference, even when at first blush things seem to be pretty disparate. It seems to be a pretty clear-cut case. I think we're running up on our time here, and I want to leave some time for questions. Do you have anything else on that, Josh?
No, I thought you covered it pretty comprehensively. So I think it probably makes sense to, yeah, actually Laura has a good point there. They have now changed the name to Public House.
Yes, that is correct. Yeah, so just a quick summary here. Obviously IP is an important part of your brand, important part of the company, potentially the most valuable asset a startup has. At the beginning, maybe it's the only asset that the startup has. So it's important to consider your IP, to make sure to protect it at the formation, when you're hiring on employees, independent contractors, and then of course against third parties through registration and filing sort of throughout the life of the company and the IP. So I think we've got some time for some questions. While Josh was talking before, there was one or two that I wanted to hit from the chat earlier. Christopher asked about developing something related to your work, but completely off work hours and off work equipment. We sort of touched on this a little bit, but not as much as I had planned on it. So I wanted to delve into that a little bit further. So again, some of this stuff is pretty fact specific. If it's something that's where you're using resources, you're doing it on company time, you're sort of in the same realm as what you're working on for the company. It's something that they're researching or looking into, a new product line, something like that. Those are things that the court's going to consider when they're determining, if you're violating your invention assignment agreement, your NDA, any of those sorts of things. So this particular question says developing something related to your work completely off work hours and off work equipment. So there's sort of a balancing test going there, right? So it's off work hours and off work equipment, which obviously sort of side with the employee being the owner, but it's something related to your work. So the company's going to say, that's nice that you developed that on your own time, but the reason that you're thinking about it and the reason that you had this idea is because you're working on it for us. It's a very complicated case, but something that I've read up on a little bit is the creator of the Bratz dolls, those horrible little bug-eyed dolls that are popular for some ungodly reason. The creator of that used to work at Mattel, and so his argument was basically, "Oh, I created this on my own time." And they say, "Well, we obviously have Barbie and a bunch of other dolls, and so you've derived your idea, your concept from work that you were doing for us." And again, it's much more complicated than that. That's a good example of this sort of scenario. And then oh, go ahead.
I was just going to say, we had a question around whether or not getting a U.S. patent protects you internationally. And we didn't touch on that. So maybe you could just quickly tell them the answer to that, which I believe is no.
Yeah, I mean, so this is all, U.S. law at some level, and then California law more specifically as you drill down. My understanding is that these don't have the same sort of international protections that it doesn't apply overseas the same way that it would here. Although there's certainly more I don't know what you call it, interplay between U.S. and European and Chinese IP law as stuff gets more international. So just as a general statement, U.S. patent protection is not going to be enforceable or necessarily apply in China or Europe or wherever you're looking at, but certainly helpful in protecting your rights as far as you can.
Right, and building on that a little bit, with respect to copyright and patent, trademark as well, there are different treaties that are formed among the nations and there are different parties to different treaties, and there are a number of treaties, especially with copyright. But with patent, there's definitely the Patent Cooperation Treaty. And with that, you can seek protection for your patent abroad. And through that process, you can actually seek protection in a number of countries simultaneously. I'm not sure what the exact process is like, but there are certainly treaties out there for patent, trademark, and copyright to protect your rights abroad.
You basically have a time window, and then you have to file in each country under that country's rules and regulations with whatever their prices are and times. It is an eternal headache.
Yeah, it sounds like it.
Yeah. That's the same for patent and trademark. I'm actually working with some guys that are looking to use Bitcoin technology to try and introduce an international revolution in intellectual property, such that we can avoid some of this, but both trademarks and patents, all this multiple filing in multiple countries and stuff. So that's interesting stuff. But yeah, it's a pain in the butt. Lost all my money trying it.
So Josh and Justin, we're just about out of time. We can stay longer if you have time available. You need to let me know if you're open to answering more questions or if you have a hard stop at one.
I can go a few minutes over.
Yeah, same for me.
Okay. All right. So there's a question about what you would advise to protect intellectual property on a smartphone app. So I'm assuming this is software.
Yeah, I mean, software is going to be a patent deal first and foremost, and partially could be protected with trade secret. I mean, honestly, if you really want to go the whole 9 yards with protecting IP, you could also protect part of the code as copyright. You could protect, obviously, the brand name that becomes associated with the app. That can be protected as a trademark. Any logos can be protected as a trademark. I think the primary protections for an app are going to be under patent and trade secret.
And a lot of that, the way that I envision this happening, right, is invokes a lot of the stuff that we talked about with employees and independent contractors. I mean, I'm guessing there's going to be pieces of it that are either, you've got some base that you're starting from and adding on in terms of the app, or maybe you've got independent contractor that's developing a portion of it or some aspect of the technology that you're going to be using. So this sort of invokes a lot of the stuff that we talked about. I know Willie said he was called away, so he may have missed some of that, but I think we've got it on the recording, so maybe you can go back and get some refresher on some of those aspects as well, because it's like we talked about, it's important to make sure that you protect it through registration or through trade secrets if that's the route you're going. But it's also important to make sure that you actually have it and control it to make sure that it's yours to protect.
And Daniel has a question about trademarks. He wants to know if there's any issue with using clip art images as part of your trademark.
Yes, there is. And it's actually, clip art for the most part isn't really a trademark issue. It would be a copyright issue, because even though you could theoretically be incorporating it into your branding, which is what happens most often, you are using it as a trademark, but Microsoft doesn't use clip art as a trademark. They use it, it's just a design for them. And so it's not technically trademark infringement of their rights, but it is a copyright infringement because you're actually utilizing their copyright protected image as your logo. So that's pretty clear infringement. It's a serious issue.
Okay, so if you've got a new question, let us know. Let's see, do you have independent contractor, whoops, oh, that one's off. Do you have independent contractor protection if the contractor is not in the US?
Yeah, that gets pretty complicated. It's similar to patents. There's these sorts of rules. The stuff that we talked about is generally, like I said, US law and then California law specifically. if people are in Russia or India or something like that, developing something for you, it's still important to put these sorts of things in place, but the enforcement mechanism is going to be different. I mean, you're chasing somebody down in a foreign country. You're going to have jurisdictional issues, venue issues, and then just, sort of getting something out of them is going to be more difficult. So when we've dealt with this stuff in the past, we always recommend still having these agreements and these protections in place to put you in the best position possible. But it depends on what jurisdiction you're looking at, how much that's going to be able to protect you as a practical matter.
Okay, and we have a question from Tiffany. She wants to know if there are infringement tests for design patents. She makes and markets a line of designer handbags with form, function, and materials. So she's asking what tests she should lock into to ensure she can leverage specific elements of her design, of Louis Vuitton design that she greatly admires.
So I would definitely look to the ordinary observer test. I mean, that's the test that applies in design patent context. I can't provide you with the greatest analysis of how to walk through that test just because I don't deal with those sorts of things. But what I could say for certain is that you should be very careful about emulating certain aspects of LV products because they are very aggressive in their IP protection. That's not to say that you shouldn't use things that aren't necessarily protectable. I mean, if they're not protectable, they're free game. But with that said, I can tell you that there are plenty of large corporations who will abuse their rights and do everything they can to try to stop somebody from competing, even if they know that they're not ultimately going to be able to vindicate those rights if it goes to litigation. For example, and I think this is the most common example of these types of abuses. If you're ever watching a sporting event on TV, you'll always see these copyright, this broadcast is protected by the MLBPA, blah, 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 blah. You can go to prison. You can do this. This could happen. Do not copyright or reproduce any portion of this entire broadcast. Any portion, like any portion, even a small clip. Of course, that could be replayed. It could be used for fair use. It could be used for, reporting. It could be used for education. It could be used for a lot of things. But if you take it from the MLB directly, you shouldn't even put a second of their video on TV or they're going to take you and you're going to go to prison. So I mean that's obviously not the case, and that applies across the spectrum. Duke University is very, very aggressive. For example, I've seen them harass very small startup companies, and LV is sort of in the same boat. Maybe not as bad as Duke. I actually happen to think Duke University is pretty bad.
Okay, any last questions? Okay, so I'm gonna, because we're over time, I'm gonna wrap this up. I know some of you are on your lunch hour.